Hi, my name is Megan. I'm here for the girls' track team. So making fun of men participating in sports. This is what she was fired over. And Justice Thomas puts it all in there, including a quote from Tom Sowell, who is one of my favorites. Racism is not dead. It is on life support, kept alive by politicians, race hustlers, and people. So we represented a teacher up in Massachusetts who was fired. She literally just started work, and she was fired for posts she made before she worked. Just straightforward posts criticizing some of the craziness by the left. And so we took it up to the Supreme Court on behalf of our client. And the court declined to grant cert, meaning they declined to take up the case. But what was interesting is that Justice Thomas issued an opinion related to the order denying cert. Let me go back to the press release so you can look at some of the details with me as I look through it. So the Supreme Court denied its petition denied our petition that challenged the lower court decision against Carrie McRae, a Massachusetts high school teacher who was fired in retaliation for social media posts which decried woke values such as critical race theory being taught in schools. The posts predated her employment at Hanover High School in Massachusetts. Judicial Watch argued that the Supreme Court should take up the case as the lower court misapplied the First Amendment and Supreme Court precedent. And as I said, let's cut to the chase. Carrie McRae was fired because she spoke out against woke critical race theory before she was hired. The Supreme Court's decision not to take up this case is a missed opportunity to defend and protect the First Amendment and the Constitution. Now, Justice Thomas's decision, or concurring opinion, so he agreed that the case should be not taken up because it didn't necessarily put front and center, according to Justice Thomas, an issue that the court should and could hear at that time. But he did raise significant concerns about what happened to McRae. And he issued this opinion here, and let me bring it up for you, because he even included the pictures that she posted, or the memes that she posted for which she was fired. So I think it's here. Oh, this is going to be a big one. Hold on, guys. Oh, here it is. I can see the pictures here. So you see these pictures? There's a picture joking about, I forget his name now. What's that person's name? You're all telling me as I'm blanking out on it. I guess it doesn't matter. Rachel Levine, that's who she is. Who he is, she calls himself as he. And then there's this picture of this big guy. Equality doesn't always mean equity. Hi, my name is Megan. I'm here for the girls' track team. So making fun of men participating in sports. This is what she was fired over. And Justice Thomas puts it all in there, including a quote from Tom Sowell, who is one of my favorites. Racism is not dead. It is on life support, kept alive by politicians, race hustlers, and people who want to get a sense of superiority by denouncing others as racist. And this is what Justice Thomas said, in part, in his decision. The First Circuit's analysis strikes me as deeply flawed. The First Circuit is the case over, is the circuit that handles Massachusetts. To start, I do not see how the tone of McRae's post can bear on the weight of her First Amendment interests. Speech on matters of public concern is at the heart of the First Amendment's protection. And the inappropriate or controversial character of a statement is irrelevant to the question to whether it deals with a matter of public concern. Humor, satire, and even personal invective can make a point about matters of public concern. So you may not like her posts, but it's no basis to fire her as a government employee. It was on her own time. It was before she was hired. It undermines core First Amendment values, he later says, to allow a government employer to adopt an institutional viewpoint on the issues of the day, and then when faced with a dissenting employee, portray this disagreement as evidence of disruption. And the problem is exacerbated in the case of an employee such as McRae, who expressed her views only outside the workplace and before her employment. So this isn't the only case we've been working on related to teachers and the free speech rights of teachers. We represented Coach Mike Flynn, who was fired for protecting his daughter, his young daughter, because he was complaining about the woke garbage she was being taught. We settled that case. We have an ongoing case in Illinois, kind of a similar issue. Let me get the detail on that so I'm not going off the top of my head. In 2021, we filed a federal civil rights lawsuit on behalf of a tenured high school teacher. Ms. Hedgepeth, who was fired by the suburban Chicago school district where she had worked for 20 years after posting comments on Facebook criticizing the riots, violence, and shootings in Chicago in the aftermath of the 2020 killing of George Floyd. Hedgepeth made the post on her personal Facebook page while vacationing after the end of the school year, just as some of the most severe violence was occurring. In her post, Hedgepeth recommended studying Thomas Sowell, there we are again, whom she described as a treasure and a truth seeker, and praised political commentator and activist Candace Owens and talk show host Larry Elder. Larry's one of my favorites. She alleges that the firing violated her First Amendment rights. So that case is still percolating along. I think it's on appeal. So she's posting comments from her Facebook while she's at the beach. She gets back after 20 years and gets fired because she said the wrong things about that offended the race mongers and race baiters that were controlling our country, and in a sense after the George Floyd killing. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.